I don't think we equipped. Maybe Honourable Breitenbach is in a former job, but we're not equipped to, or maybe Mr. Novalo as a practitioner. Thank you, Chair. I'm sorry if I'm not being particularly helpful.
Yeah. No, let's do this now. Okay. Can I hear you?
Thank you, Chair. Yes, Chair. In the defence of senior counsel, he is not known for being a criminal lawyer. His expertise lies elsewhere. I honestly submit, it's my view, that we're about to seriously prejudice Mr. Chetty. Whether he realizes it or not is not really relevant. We're about to do serious damage to whatever case he may have. And I would urge him to not proceed with this. We can take note of this affidavit. There is stuff in here that is concerning, but we can read it. If he opens himself up to questioning, Chair, I foresee serious problems that I'm not entirely sure that I'm comfortable to participate in. Because once he does that, it is our job to question him, and he will really not come out of it well. And it can only prejudice his case. I don't know if his lawyers know that he's here. Certainly if he was my client, he wouldn't be here. And this, the contents of this affidavit, apart from the suggestions that there is foul play with the investigators mentioned, which we already have heard of them and we can take note of and look into, the rest of it is not relevant to this committee's inquiry, in my view. And so we're going to spend a day trawling through, with respect, irrelevant information, not even evidence. And it's the prerogative of a prosecutor. It's not this committee's prerogative. It's not even the court's prerogative. It's the prerogative of a prosecutor to charge people as and how they wish, and to group charges as and how they see fit within the prescripts of the Criminal Procedure Act. It's a very difficult thing for anyone to interfere with, because there's a certain game plan. Of course, every accused is entitled to be charged with everything at the same time, if it happened at the same time and place under similar circumstances. But if not, no. The prosecutor charges in the fashion that they see fit, and nobody can interfere with their discretion. So this committee certainly can't. We can't help him with that complaint. Richard Shabalala is a prosecutor of many years' experience. Paul Lowe is a prosecutor of some 40 years' experience. They certainly know their way around a criminal court. And I'm sure that they're both watching TV right now, waiting for the questions to come. Because please believe me, they will use it against him. And there's nothing to prevent it being done. I really urge us to reconsider what we're busy with here today. Thank you, Chair.
Can I rotate you, honorable members, in here?
Thank you so much, Chair. I think what Honorable Breitenbach is raising, Honorable Vessels would have shared it with me yesterday. And unfortunately, the same concerns that he would have raised yesterday, I didn't get an opportunity to look at the affidavit at that time. But I think it's quite concerning, one, when the evidence later says the actual complainant is not the person who's in front of us. Someone else submitted the complaint, but someone else is appearing before us. Maybe the evidence leader would actually explain to us, boss, if I hear this properly. He actually says, I'm not sure the father submitted, something like that. But as I say, he will actually explain further so that for our understanding of what he's saying. Two, Chair, I think it's important. It would have been raised by members on our housekeeping committee meetings that between the evidence leaders the legal unit of Parliament, and the Secretariat. There must be a way of checking unto the nature of the people who apply to appear before this committee. Because it's quite cumbersome now. If every now and then we are to discuss in this setting, in the presence of the person who would want to come and present to us, in front of South Africa, that no, this person was not supposed to be here. The nature of that which is submitting to us was, it would, in our view, Chair, that they would brief you about the nature of that particular submission. So that you come to the committee and advise the committee better, so that the committee takes a decision whether to invite or not to invite that particular witness. But it's becoming a problem. Now, we agree, Chair, the nature of what is said in the affidavit requires a competent court of law. And it's a detriment, it's a legal detriment to Mr. Chetty himself to come and answer here. And you'll recall, Chair, we would have said, in a number of witnesses, they are not at liberty to come and tell us what to ask and not what to ask. But when the evidence leader and Mr. Chetty are starting interacting, there is already a condition that I'm not prepared to answer this matter and this matter, then this matter, because it's in court. Now, consistency compels us to say, we have said to General Patlane, we have said to so-and-so, that they are not going to put forward conditions for us to proceed. Now, part of what we pick up from Mr. Chetty's argument in the affidavit is that there are people who are charged by the state to preside or process his cases, which some he accuses of them having been convicted before, both at IDEC and some having been subjected to an internal DC of SAPS. That's a matter, Chair, that I think if we agree on an approach, just to say from IDEC head and SAPS, give us a status of so-and-so, whether or not they got charged, whether or not they were disciplined, whether or not they were convicted, and all those things. But it still matters that Mr. Chetty and his legal representative must raise in a court of law that the nature of how the state has processed my cases has got these irregularities. So I believe, Chair, and we agree from where we're seated, that it's not only a problem of the committee, it's majorly the problem of Mr. Chetty to come and divulge some of the issues in this particular platform that are still subject of a competent court of law. We'll all agree, Chair, that the rules of the National Assembly do not allow us to get into the merits of issues that are still sub judice. So I think, Chair, we must plead with Mr. Chetty, and I'm worried. This may appear as though that we don't want Mr. Chetty to come and talk to us. We'll recall that this is the second time we're discussing his matter, and I'm asking him to go back and come back and all that. It may appear, Chair, that we don't want Mr. Chetty's testimony and all that. But the major concern is that we are to respect the state process and the judicial process. And we are not willing to be part of ruining his case and his presumption of innocence. So it's us pleading with him that he must reconsider, then we'll take it from there. Thank you very much, Chair.
Honorable Nomvalo.
No, thank you, Chair. Chair, initially when Honorable Breitenbach was raising the matter, I was agreeing with her overwhelmingly. But there's an aspect which I don't agree with. When she wants to project certain people against whom complaints have been laid in this affidavit as a paragon of virtue. He's even citing their experiences and so on. I think that is unfair and that is being argumentative against the witness before us, because we must be fair to witnesses here. Allow a witness to present, and then when he has presented, you make your arguments. Not to say when a witness has not even opened his mouth, the people that you are complaining about are competent people, they have experience and so on and so forth, as if the witness is hallucinating. That witness is raising these complaints out of frustration. I understand the legal aspects and the legal concerns that Honorable Breitenbach is raising, and I agree with them to say it's going to be prejudicial to the witness when he deals with matters which are before court or which are pending, because even with us, it's going to be difficult to interrogate his testimony, because we will interrogate it with caution. We won't understand to which extent we should go, because we will be trying to save her, and we will be trying to save his right to be innocent to be presumed innocent before he's proven guilty. So, but the problem here, Chair, is that our house is not in order. It goes back, and I'm afraid now that witnesses or members of the public largely are going to be on the receiving end of our demise as the committee. But that demise is orchestrated by the legal team. We raised this thing in one of our meetings, Chair, and we asked a question that, what is it that a witness with the evidence leader do during consultation? What are they doing? If here in this committee we deliberate on issues that are supposed to have been dealt with during that consultation, because they have been employed to do exactly that, to say this evidence by its nature does not belong to a committee. Maybe you must submit a written statement, or maybe you must apply to tender this evidence in camera because of its nature. That guidance is supposed to be tendered during that consultative process. But it does not happen. What are they doing? Maybe Advocate Arenzo needs to tell us. What are they doing during consultation? Are they guiding witnesses on legalities or not? Or they just accept, they just say, no, bring everything, we'll just pass it as it is to the ad hoc committee. So I'm very worried, Chair, in as much as I agree with Honorable Breitenbach that now we want to turn away a witness who has come here under an impression that he's going to get an opportunity to explain his side, and who was going to do otherwise if he was properly guided by the evidence leader. So he has been failed by this committee. He has been failed by the evidence leader. And now we want to suffocate him. We want to turn him away. He has compromised all his schedule to come before this committee and argue for his case. When we are here, I understand, members, because we knock off at night here, so we don't get time to read these statements. I've only read it now when I'm here. And I'm getting concerned as I'm here as to what is it that we're expected to do here when a statement from page 1 until the last page talks about cases which are pending before a court of law. So what are we expected to do as members of this committee? So, Chair, I know we're towards the finishing line. We're at the tail end of this process. But our concern remains very high against the evidence leader and his team on how they conduct this work. They are not doing their job during consultation. That is why sometimes we read 180 pages, which is full of irrelevant content. Because during consultation, they must say, no, this one, Advocate Patlane, when he was here, was told by members that, no, these are labor issues. Those are the issues for which he was supposed to get guidance during consultation. To say, no, this one does not fall within the terms of reference. It must not go to the committee. because he has been employed to do that. So, Chair, unless the witness before us feels strongly that he wants to continue under the guidance that we have given him, or under even after the concerns have been raised about the risk he is imposing himself to, we are saying we're of the view that he must submit rather a submitted a statement, I mean a written statement. It's unfair to say he must not submit anything at all, because he's complaining about the judiciary here. So when you say the matter is under a competent judiciary, we are already making a judgment that all the complaints he's raising are invalid, because the institution that he complains about cannot help him if he feels that it is compromised. How can you complain to the same judge that you are complaining about, to the same magistrate that you are complaining about? So let the client not be helpless. Let's not make him vulnerable and say, no, go away with this statement, we can't help you. If he continues to feel strongly that even after this he can continue, it's fine, he can continue. But as this committee, we have been honest to him to say this is prejudicial, but if he wants to continue, can continue, Chair. Thank you.
Honorable Breitenbach,
Chair.
do you want to speak?
Oh, yeah, Chair, just on one point, I didn't mention Shabalala and Lowe to suggest that they're untouchable. I mentioned them to suggest that they have a lot of experience and they will be watching this because it's an opportunity they wouldn't let go by. Not any other reason did I mention them. Yeah.
Okay. The EFF?
And Chair, I remain deeply uncomfortable with the process.
Okay.
I'm not sure that I want to participate.
Sure.
Thank you, Chair. Hey, it's embarrassing. We are an embarrassment to the people that have elected for us to serve here in Parliament, that we can even sit here and while after a witness is even sworn in, that we raise things that should have been resolved a long time ago. I echo my colleague's point of the issue of resources for this committee. I disagree with him that we must put the blame squarely on the evidence leaders. Literally, we have 3 evidence leaders. If you go to that commission, who's pretty much has the same number of witnesses that we are dealing with, they have like a whole team. Our legal team here, our technical team here, they're not here full-time, Chair. And we've been raising this for a very, very, very long time. We even got a letter, or finally the letter was circulated on why we don't even have a forensic investigator. We are an embarrassment to the people who voted for us. Parliament is an embarrassment not to provide adequate resources. And it's got absolutely nothing to do with the fact that we don't have money to be able to serve South Africans with the dignity and the efficiency that we need. It's just embarrassing. And on the merits of what has been raised here, I think it's highly disingenuous to talk about active cases. Pretty much every single person that has come here, senior officials of SAPS, they have active cases. It's not going to be the first time that we've had witnesses, even in committees, where they say, I can't respond to that because it's in court. So to all of a sudden feel uncomfortable participating because someone can be prejudiced is, I don't even know where we're pulling that from. It is something that goes on here. It's even weaponized in this Parliament, even in committees, that we shouldn't ask that question because that question is going to jeopardize the case. We hear that. It's a long sing-song story. Mr. Chetty has been here. This is his 2nd time. The first time we even sent him away. The fact of the matter, whether this is related directly to our terms of reference or not, it's a bit late. So unfortunately, we're going to have to take his case. There are matters of SAPS that are involved in here, and we are going to hear because we are the People's Parliament, and there's nothing in here that's not related to SAPS. It might not speak directly to the terms of reference, but we are here. We'll hear from Mr. Chetty if he's going to feel like he's compromising his active cases or not. But the story of that prosecutors or whoever's going to be prosecuting his case are listening and is going to be prejudiced, I don't see how that has any relevance here at all. Everybody comes here and they say, I can't answer that because I have an active case. And we allow it. It happens many, many times. So it's up to Mr. Chetty. We are here. It's our fault here. We've let South Africa down. And Mr. Chetty will make the call. Thank you.
Bangazita.
Thank you, Honorable Chairperson. Yeah, I also do feel that it is unfortunate that we are engaged in such a discussion at this point. In fact, midway through the presentation of the chief evidence by Mr. Chetty, it's something that we should actually have dealt with before he came here. Now that he is here, and there are concerns about incriminating himself on some of the issues, because most of the matters that he is actually presenting here are before court. I don't see how that is different from General Pahlane's cases, for instance, because he also had a string of issues that
try to treat everyone in the same way.